Take the floor in three, two, one.
Hello and welcome back. The time is promise time. It is that time. It is that time. Promise time. We promised we have to deliver. I'm telling you right now, we regret the day we promised that we're going to be live in any of these times, either Saturday or Sunday. And it's Monday now. It's when we are live. And I'm telling you, for free, without anything, we probably are regretting that. We should have done that thing and get it over and done with. But it is Sunday and we are here. Yeah. And probably going to be here tomorrow. That's the thing. These promises, they never stop. They come and go, but you need to keep them. So, right, if you ask me if I would rather be here or just be sleeping somewhere, definitely I would choose sleeping. But unfortunately, there is an episode that was not done. And we are here because of that. I don't know if you guys are hearing the news of I'm not going to call the name. But yeah, the guy who started some fight somewhere. Yeah, there's a picture of him coming. I don't know what it is. For me, it looks like AI. But yeah. Impi, ayidlali bafowethu. Asingayichoose impi. So yeah, on this day when we were supposed to be here, what happened is, I'm not going to remind you guys to like the video. I know you're going to do that. So what happened is the defense decided to have some moment and have a conversation with their people that they are representing. So the question is, what do you think that was? Now I can tell you for free, they definitely are procrastinating about what is going on with this judge, because it seems as if each and every day Ushiselung Mpepo now and then is just doing things that are out of line, if you ask me. So they were like, no, man, we need to do something. As I said, the time is now or never. In my opinion, this is the right time to launch a complaint about the judge, because he is not behaving like a person who is there to actually make sure that the law takes its place. So they needed probably that time. We are not sure what the time was for, but in my opinion, these are things that are rising on the minutes that probably would point to that direction. So yeah, things are happening around the world. You know what is happening. You know the thing of oil, the dollarization and whatnot. But things are happening. But for it to maybe this is a good lesson right now, not to undermine your opponents. So we are seeing that in that court.
Yes.
That the opponents are undermined. Let's see what they can do if they can pull this thing that the other, the other country pulled. All of a sudden, people are coming to actually make sure that we know that they are still alive. It's tough. It's tough around here, man. You can undermine a person, next thing you find yourself eating the dust. So that is none of my business.
Yeah, now he was quiet for quite a while. It's unlike him. Unusual.
What? Being quiet? I don't know, man, what's going on with him. I don't know. For me, he's not acting like a judge. He's not acting like a judge at all. For me, he is just showing off his attitude. And that's what probably he has been doing for all his life. The only mistake is he decided to come back on this case. And that is probably the biggest mistake that you can ever do while the case is on a microscope and everyone's watching. So let's hear what this court had for us. It's a kangaroo court, to say the least. And we must call it what it is. It is a kangaroo court. Right. So, Emily, how are you doing?
A bit tired, but that will be okay.
Yes, a bit of coffee and coffee and coffee
Yeah.
can sort that thing out. And we hope that happens very fast. You catch up very fast because look at Mr. Anonymous. He's awake. You don't want to sleep on the mic. They will never let you slide.
Let me rest. Hi guys, welcome back to the Mzansi Reality YouTube channel. Thank you so much for joining us here again for another deliberation of the Senzo Meyiwa trial. Yes, as promised, we did say Saturday or Sunday, but you know what? Over the weekend, things get hectic. It's people now wanting your attention to be diverted somewhere else. Family stuff, it just gets hectic, but we managed to make it. Let us just thank God we made it, okay? So I couldn't afford to miss out on the proceedings on Friday because I feel like a lot happened that we need to talk about. It was quite a slow day in my opinion. It was a slow day. It was not a day that was filled with too many zgatlas, but there are particular things that perhaps we'd pay attention to, like the fact that it seems like, or maybe it's too early to say anything because the defense is so discreet about it. The defense counsel said that they were, taking instructions from their clients earlier on, and it looked like perhaps there are deeper, more meaningful conversations taking place, that perhaps it is time to start that application, to launch that application, okay? And it would be, like Mr. Anonymous says, a wise move to do it now. It's a window of opportunity to actually do it. I don't think there'll be any such golden opportunity like this one, considering the fact that even the prosecutor is planning on keeping Tanzi on that stand for God knows how long. It's a perfect time, in my opinion, to launch that application, especially considering the prosecutor doesn't want to sit down. They keep asking Tanzi the same question 15,000 different times, hoping to get a different response. What is that if it's not badgering a witness? So the court resumed with Advocate Nisi asking for an opportunity to address the court. Nisi said, "My apologies, our clients have entered here, and there is something that they are still busy conveying to us as the defense team. Unfortunately, when they were still busy with that, then the court got in, meaning that the judge got in. And then Nisi asked for a short adjournment for them to take instructions. He said that, they will, or he will inform him once they are done. It was quite a long break. I think it took approximately an hour, if not less. So they were taking instructions from their clients. And when they returned, Nisi thanked the court for giving them the opportunity, said it was invaluable. They proceeded to take instructions from their clients. However, they need to go and do a thorough research to try and find out, to bring them a precise answer on the course of the next week. However, that should not preclude that the trial should not proceed. And the judge said, okay, fine. But then the main question here is, do you guys think that they'll be launching that application eventually? We are speculating for now, but I also would like to hear from you guys. Do you think that that whole taking of instructions was pertaining that maybe the accused feel that, it's time to launch an application against the conduct of the judge? Remember that Zulu had actually launched it, or had planned to launch. He actually launched it. He informed the judge before he passed away that I'm launching an application. And honestly, I don't want him to stop with this case or presiding over it. But I wish that they can do the application as the cause of the application takes place. He needs to be made aware that what he's doing is wrong, and there's nobody calling him to order concerning his conduct. So that application has become a necessity now, where he keeps repeating the same intrusive things that he does in that court, and it stands up for the state and becomes the state prosecutor. So we don't know whether he's a prosecutor or a judge because he's playing both roles. So they need to launch that application.
He is one might say an advocate for
For the prosecutor. I think the mic is off. The mic.
He is, yes, thank you. He is, in my opinion, an advocate for a prosecutor who's an advocate himself. That is very disturbing.
He's a defense counsel for
He's
the
just there
prosecutor.
defending everything that Baloyi does wrong, in my opinion. I don't think
Sometimes he even takes over from Baloyi. Something that should be done by the state. He's busy there doing it. Then you're like...
I don't think the defense see that they will get justice under this charge. I think now it's clear.
Yeah, now it's clear.
That there is no justice for their clients when it comes to this charge. So
now it's clear.
It's time for the defense to make a move.
Yeah. So Baloyi also resumed with the police call me's that were sent to Mjiako by Ntanzi's number while he was in custody. He said that he had already gone through them before, but he will go through them again to contextualize the relationship between Mjiako and Ntanzi. Ntanzi said no, he does not have a relationship with him. Even now, he doesn't have a relationship with him. So Baloyi referred to the proceedings of the 20th of August 2020 at Tlhabane Court, and Mjiako was on record for the third time. Baloyi referred to the please call me from Ntanzi's number ending 6890 to Mr. Mjiako's number ending 7605 starting from the 31st of October.
Is this the number that was denied? By the state.
The number of Mjiako. Was it ever denied?
No, I'm saying the number that they are using now, Ntanzi's number.
Oh, the other one. He reverted back to the old one, the one ending with 6890.
The one they didn't deny.
Yeah.
Okay.
He reverted back, and it's kind of a repetition in my opinion. He keeps repeating evidence. He keeps repeating Baloyi. I don't understand what's wenzagalan, but at least something different will be happening tomorrow because they'll be talking about him admitting something else. Konje, what is he admitting? He wants to go through the bail application, the affidavit and Ntanzi.
Oh yeah.
So maybe that has something different because right now it's badgering, honestly speaking. He keeps repeating the same thing, the same line of questioning over and over and over. He will leave it for a day, come back to it. Right now, on Friday, at this moment, he went back to Mjiako again.
Obviously, Mjiako plays a pivotal role. Why would they have brought him if he's not supposed to play a role?
If he had a pivotal role and it was that crucial, I don't understand why there's no communication with Mjiako to bring something solid, because these things that they've brought so far, they're not sufficient to confirm that Ntanzi did give Mjiako instructions to represent him.
So what they want to allude to, because you can almost see what they try to do these days. So they want to say the family called Mjiako, and upon calling Mjiako, then they called Ntanzi, then Ntanzi, then please called Mjiako. That's what they want to say.
Even though they didn't know when Ntanzi was, but they knew where to send Mjiako.
Yes.
To a company to take a confession.
Because according to them, that's not true. That Ntanzi was not known to the family.
Well, he was not. Ntanzi wanted toiletries and things to bath and change of clothes.
In that court, what Ntanzi wanted, whether Ntanzi has proven beyond reasonable doubt that he was actually not known at the time by his family, it's irrelevant.
And the fact that he's the only one from his family gainfully employed.
Irrelevant. According to that judge.
I was thinking in, because a lot of things don't add together. Well, Baloy said your number on the 31st of August 2020 at 17:42:28, and please call me to Mjiako's number 07 whatever at 14:33:28. 4 minutes later, on the 31st of August, another call me. So he went through the call me's until he asked Ntanzi for a comment. I'm not going to go through them, I'm bored. Ntanzi said, "My lord, I had no phone. My phone was confiscated from me on the 16th of June upon my arrest. Before the court, I did mention that my mother's number is called, and then Lebuhile's number is also called, then it's Mabena's number. Right now, you are reading where you are reading that I sent callbacks to Mjiako's number, but here is Mabena's number. You are not reading it so that it can also get into the record. You are not reading it. I did ask that my mother's number appears, then Mabena's number appears, then it's Lebu's number, then it's Mabena's number. Mjiako's number appears, that I don't know, by the way. He says he doesn't know Mjiako's number. Then it's Mabena's number. All of them follow each other. How does that happen?" Well, Baloyi said, "Sir, we've explained to you before that in re-examination, your counsel will be at liberty to take up any issues that you'd like him to take up with arising from cross-examination." Then Tanzi said, "I also have a right to inform the court if I don't see clearly." Well, then Baloyi said, "We have presented records from the LPC indicating that this number belongs to Mjiako." Tanzi said, "I never said that that was not Mjiako's number. I said that I don't know that number."
I think Baloyi has realized that answering Tanzi or even trying to take any debate further with Ntanzi has actually done him so bad. So now he has decided to become a selfish lawyer that he is, allegedly. So he's now saying, "Okay, I'm not going to answer anything coming from you. So whatever I put, and please don't take anything further with me." What is good about what Ntanzi is doing is highlighting, is making it easier for Ramsipiri to say, "You need to clarify this with me," because obviously Baloyi is not going to do that for you.
Yes. Baloyi continued with the please call me's and messages. You know, he started with the 9th of September. He was on the 31st of August. Now he went to the 9th of September, 10:44. Sent a please call me to Mjiako's number. And he said that your number on the 9th of September 2020 at 11:27, send a please call me to Mjiako's number. Then he went on and on reading the please call me's. This time around he took quite some time, and then eventually he asked Ntanzi for a comment regarding the please call me messages of the 9th up to the 10th of September 2020, and Tanzi said he did not have a phone, and he also asked, "What I'd like to know is, did you find this number saved in my contact list?" Mjiako's number. He was asking if it was saved in his contact list.
Yeah, a very valid question that Ramsipiri needs to take up with Ntanzi. Part of the clarifications to say that this number is new to Ntanzi. It comes as a number that came as a new number. And upon that, it then starts being sent please calls for a lawyer that is supposed to come. And the lawyer does not call. He just knows that he's supposed to come and meet Ntanzi.
And if you are going to also say the lawyer got contact from the sister, okay, fine.
How does he know he's supposed to come and meet Ntanzi with a police call? How can a police call clarify issues of what needs to happen?
Because it would be quite diabolical to claim that the sister knew where Ntanzi was. Even Ntanzi didn't know where he was. On the night they arrested him, he didn't know where they were taking him.
He didn't.
So it would be diabolical to claim that the sister knew when Tanzi was and then told Mjiako to go there. Totally diabolical. Well, Baloy said, these are Section 205 records, sir. If there are any other issues, as you mentioned, you can raise that with your legal representative. Baloy asked the judge for an indication that since they did not get to have a sitting in the morning, are they going to sit through the normal adjournment? And the judge said, no, we are adjourning. What time is it? At the time it was 11:21 and they adjourned. It was like you couldn't wait to get up and leave. So after the short adjournment, Baloy continued with reading more of the Please Call Me's, Bazalwan. Oh, Lord have mercy. And he did read from the 1st of October 2020 at 1949-32. He said that it sent a Please Call Me to Mjiako's number. He went on to the 12th and then he asked, do you have any comment, Baba Ntanzi, regarding the Please Call Me messages that appear on this page? And Ntanzi said, my lord, I had no phone. Then he went on to the 19th of October, read another Call Me that was sent to Mjiako's number. And he said that in less than a minute later, on the 19th of October at 9:52:09, another Please Call Me was sent. Then he asked Ntanzi for a comment regarding the two Please Call Me's on the 19th of October 2020. And Ntanzi said, my lord, I said I had no phone. I was separated from my phone on the 16th of June. And then he went on to the 27th of October now to read another Call Me. It was October 2020. And he said, recall that it is the date on which you appeared at Boksburg Magistrate Court at 8:04:33. You sent a please call. Your number sent a Please Call Me to Mjiako's number. Do you wish to comment regarding this Please Call Me message? Well, then Tanzi said, I had no phone. I got separated from my phone on the 16th of June 2020. And these callbacks are not revealing towers as to which tower these callbacks were being sent from. Because at this time, as the prosecutor is indicating, I was in court. The time there is 8:04:33 in the morning. And the towers are not indicated as to where these Please Call Me's were sent from, which is strange.
Very strange, obviously, but there's nothing strange with this court. I mean, the AVLs, they forget at the right time where they are at. They start loading or doing whatever that needs to be done. Nothing surprises me in this court.
But I said you were due to attend court on the 27th of October 2020. Now altogether there are 12 Please Call Me's sent from your number to Mjiako's number from the period of the 31st of August 2020 to the 28th of August 2020. Tanzi said, I hear what you are saying before the court, but I had no phone. Even now, I'm still complaining, lamenting before the court. If you look at the time the call back was sent, you see Mabena's number was also, sent a Please Call Me. At the very same time, you then ask yourself, what is it that is happening? There's just a difference of seconds in time with regards to this number that is claimed to be Mjiako's number and Mabena's number. And remember, this is the morning where he's going to the Boksburg Magistrate Court. And at around 8:04:33, his number is sending a call back to Mjiako's number. And this is the 27th of October when they were appearing for the Senzo Meyiwa Murder Trial at Boksburg Magistrate Court for the first time since he got arrested in June. Well, then Baloy said, thank you. Can we then move to the calls between your number ending 6890 to Mjiako's number on the 10th of September 2020, 19:18:58, received an incoming text message in an empty SMS lasting 0 seconds from Giaco's number. Do you have any comment regarding this call that appears on this page? Ntanzi said, there's nothing I can say because I had no phone. I was separated from my phone on this June 16. I will repeat this and tell the court that even now, just above the number you said it's Mjiako's number, there's Mabena's number, and then there's Mjiako's number underneath around the same time at 7. And another thing one would say is to trick and confuse Ntanzi. Why are you not mentioning the call data the way it follows each other chronologically? Why are you calling the SMSs or the please call me separately, and then you are dealing with the call logs separately? What's up with that? Why is he not following like a time? You send a please call me and then you receive the phone call. Like why why is it so messed up? Why is he putting please call me's one side, then the calls one side? Why is he doing that?
His aim is to paint a picture of Ntanzi having engagement with certain people. His aim is to make sure that Ntanzi has a phone in whatever cell that he was at. That's his aim. So the chronological order, it clarifies things. I don't think Baloyi is looking to clarify things there. He's making sure that it sounds and it looks like Ntanzi had his phone in that holding cell.
And then some people had heart palpitations when they keep saying that he's misleading the court.
Obviously, he is.
Well, Baloyi asked Ntanzi to identify the number, and he said that it belongs to Mabena. Or the number that Ntanzi said belongs to Mabena. Ntanzi actually called it out in full, and he was looking at that paper while he was calling it out on full. He said 0761400918, and Baloyi said your number 21st of September at 18:52:02 made an outgoing call and almost lasting 38 seconds from Giaco's number, and Baloyi said 50 seconds later, your number on the 21st of September at 18:52 received an incoming call or MTC lasting 113 seconds from Giaco's number. And your number on the 21st of September at 19:42:30 received an incoming call or MTC lasting 121 seconds from Giaco's number. This is the 21st of September 2022. The tower is Queenswood, and he said even for the other previous calls, the way he did not mention the towers, it's Queenswood as well. And then he said, do you have any comment regarding the calls of 21st of September 2020? Ntanzi said, I'm still standing before the court and I'm saying that I did not have a phone. I was separated from my phone on June 16. In court, it is being stated that Mjiako is my lawyer. I am asking that you explain to me, assist me, and put me at ease that as you state that Mjiako was my lawyer on the 23rd, 24th, and 25th, is there his contact here amongst my contact list? If you are saying that he was my lawyer, please heal me by telling me the truth. Tell me where on that part before the court. Please indicate to me those contacts if they are listed here. So he wanted to know if Mjiako's contact was in his phone book or contact list, number one. And I feel like it's an important question because one has to ask themselves, okay, if he's not appearing on Ntanzi's contact list, where did Ntanzi get Mjiako's number from while he's in police custody? If you're going to claim that he had his phone with him.
It's unexplained. And I'm telling you, Judge Know-It-All would not see that.
Hi, he's cruel, whatever. Baloyi then said we'll be covering some of those dates up to the 27th of October. Ntanzi said okay. Then Baloyi continued to read the call data from the 1st of October. Ntanzi maintained that he had no phone and he had 2 phones were taken from him. 2 phones. He had 2 phones. Okay? 2 phones were taken from him. So he was basically repeating Mjiako's call data Baloyi. Again, including the calls that Mjiako's number made to Ntanzi's number. But then an interesting part happened where he said, so in summary, Baba Ntanzi, regarding the calls, there were 7 MOCs or outgoing calls from your number to Mjiako's number. Baloyi then said there were 3 incoming calls or MTCs from Mjiako's number to your number. There were 3 incoming text messages from Mjiako's number to your number, MTSMS, and there were 2 call forwards from Mjiako's number to your number. There were altogether 27 communications between your number and Mr. Mjiako's number for the period of 31st or from 31st of August 2020 to the 22nd of August 2020. I am baffled at this because I was expecting the communication to have started in June. Before he went to Grunier confession taking. Where is that communication?
There's definitely no communication because, I mean, in that, you know what Baloyi is doing, what he has realized. I don't know whether he has realized it or he knew it from the word go. The judge is on their side. Allegedly.
So he doesn't have to. He's just all he has to do is be present. Okay, let us be honest. Is there any actual substance in Baloyi's cross-examination that makes you like, wow, he got Ntanzi?
No.
There's nothing. There's nothing. There's nothing. If there's anything, Ntanzi is embarrassing him. He's mopping the floor with him. He's dragging him. He's making him look incompetent. He's making him look like, yo. Hi, guys. Kunzima. Well, Baloyi ignored Ntanzi while Ntanzi asked. I don't know if I went through the question that Ntanzi asked. Okay, let's go through it. He asked Ntanzi for a comment. Ntanzi said, my lord, I had no phone. My phone was taken from me on the 16th of June. And then, you are not helping the court with the truth. Why? Because I'm asking that since you are saying in court that Mjiako was my lawyer, I'm asking that you check for me that first time Mjiako started seeing me on the 24th of June, 2020. Whether there was the same activity with my phone, because in court I did not have a phone in the company of police. That also brings the question of, just before they got the confession from Miss Grunier, there was heavy police presence around Ntanzi. So if you're going to claim that Mjiako was his lawyer, then where's that initial communication between Ntanzi and Mjiako's phone? Their phones. Where is the contact happening there just before he went into the confession? Because right now, on this call data alone, it's looking like what Ntanzi is saying is very much the truth of what happened. He said Mjiako was just chilling there while Grunier was writing the confession. And who's Mjiako? He says before, no, it was at the Boksburg court where he introduced himself just before Ntanzi appeared. And then you hear that he also accompanied him with the cases of Tlhabane Court of Ammunition that, by the way, were opened by Mogani and Mabena. You understand? But he knew the dates when Ntanzi would be appearing at Tlhabane Court? Who was updating him with Ntanzi's dates that he's going to be appearing at court at so and so a date, while he can't even present proof that he had a consultation with Ntanzi? This is weird. And the fact that this case is still it's still gonna continue. Baloyi ignored him, obviously, when he asked him and put that statement to him. It's very peculiar, strange. Where did Njiako come from? Where did he come from? Especially with the confession. I see he's dodging the confession part. He's making it seem like Njiako came at a later stage at this timeline that he gave from the 31st of August to the 28th of August, when that's not the case. What about the confession in June 24th? And where do you think Ntanzi got the opportunity and chance from the time that he got arrested? And he says they took my 2 phones. Where did he get a chance from the 16th to have called Njiako while he was under so much heavy police presence and guarding, and they were all over him? How was he ever gonna get a chance to use his phone if you're gonna say that he had it on him? Then Baloyi ignored him and said, now in summary, Mr. Ntanzi, we make the following proposition to you: that 1, given the evidence of Brigadier Gininda regarding the events of the 23rd of June 2020 at Pretoria North Police Station, regarding your interaction with him, Mr. Njiako, in the cells, Gininda said that he actually said it was moored at some point, but he went back and reverted that it's Pretoria North Police Station. Baloyi said, and the next proposition is that given the fact that Mr. Njiako appeared again the next day at the Boksburg Magistrate Court on the 24th of June 2020 before the magistrate Grenier for the confession, and also given the fact that Mr. Njiako made an appearance again at Tlhabane Court on the dates that we demonstrated yesterday, the 13th of July 2020, the 3rd of August 2020, the 20th of August 2020, the 5th of October 2020, the 11th of November 2020, and that Miss Gia from his firm appeared on the 22nd of January 2021, the 27 communications we have referred to between your number and Mr. Njiako's number for the period of the 31st of August 2020 to the 28th of October 2020, and Mr. Njiako's appearance for you at the Boksburg Magistrate Court on the 27th of October 2020 and the 27th of November 2020. Based on that is indicative that there was an attorney-client relationship between you and Mr. Njiako. Oh, what a messy question. What a messy question. A lot is going on in that question. Ramosipili stood and said that it was not necessarily an objection when the question was first posed. Reference was made to the 23rd of October 2020, and he said that my learned colleague mentioned something to the effect that there was an interaction between Brigadier Gininda Njiako and Ntanzi, but that was never completed. I don't know what was said in relation to that. Yeah, actually it wasn't. That's why even when I was reading, I kept pausing. What exactly am I reading here? Short. You know, given the evidence of Brigadier Gininda regarding the events of the 23rd of October 2020 at Pretoria North Police Station, and then it just stopped, right? And then he started a new phase, and he said, regarding your interaction with him, Mr. Njiako, in the cells, you know, and it's like, okay, what happened to that part where you are saying that, you know, what is happening there? Well, Ramosipili said
there is no order in that court. And you don't need order value if I'm telling you, if you know what is happening. If you just need to say something and spew
And
whatever
look
that you
busy.
spew. And then that's it. There won't be order of trying to prove and show beyond reasonable doubt that there was a communication. That communication actually suggests that the phone was with Ntanzi. Here are the proofs. All that is being said is that the phone was with Ntanzi. All that is being said, and there is nothing that shows that these police that arrested Ntanzi have went through disciplinary hearing because they never searched him.
No.
According to them, they are admitting into being negligent.
Yes,
And
they're
that
making
is
that
something that
admission.
should have been reported
Yes.
as they are using it in court. But it's not there because it never happened.
Well, to the effect that there was an interaction between Brigadier Gininda Mjiako and Ntanzi, but that was never completed. Ramasipili said, I don't know what was said in relation to that. Then Baloyi said that he said on the 23rd of June 2020, not October. I did not hear the 23rd of June 2020. Let me look. I did not. It's not in my notes, so he didn't say it. So he said from the 23rd of June of 2020, not October, that according to the evidence of Brigadier Gininda on the 23rd of June 2020 at Pretoria North Police Station, there was an interaction between him and Mr. Mjiako and Mr. Ntanzi. And Ramasipili said, I'll object and say that is an unfair question, my lord. What Gininda says is hearsay. Mr. Ntanzi denies that he had an interaction with Mjiako in the presence of Gininda and Mr. Mjiako in the presence of Gininda. And Mr. Mjiako has not been there has not been here to testify to confirm that. And the judge said, I know they say you are reading hearsay evidence, Mr. Baloyi. And then Baloyi said, well, we are putting it to the evidence of Brigadier Gininda. It's not hearsay. He was there. It's something that he himself experienced. And the judge said, it's what he says. And Baloyi said, yes, we've put this evidence on record. And Ramasipili said exactly that. You know, that's what he says. What does Mjiako say? Mjiako is not here. And then the judge said, no, but he is making his submission that he is quoting the evidence of Gininda, not any other person. So if I understand it, if Ratha says I play for Kaiser Chiefs, that can be hearsay, okay? And then Ramasipili said, yes, but we've seen Ratha play for Chiefs and Pirates. It can't be hearsay. We've seen him. Akir. We've seen him. There's nothing corroborating Gininda that he was there on the 23rd of June 2020 at that police station with Ntanzi and Mjiako. Okay. Is there anything corroborating such?
No.
So why must it be put as if it's not hearsay what Gininda is saying?
Because
He
Gininda
says
is
he
right.
claims to be
Gininda
there.
is always right in that court. So is Baloyi. So is everyone who comes to testify from the state's point of view.
Well, Ramasipili said, but we are saying Mjiako and Gininda and Ntanzi. Before he could finish, the judge became very irritated with Ramasipili and said, it's not hearsay, I've ruled, it's not hearsay. Yes, sis. Well, Ntanzi said, my lord, that is not true. I'd like to ask the court and put a full picture. I was arrested by Mohane and Mabena. When you get to the police station, Mohane's number is written down on the OB entry. Gininda's number is not recorded there. Gininda told the court that he was called at Pretoria North or Moot. I don't recall that. Where did they get Gininda's number to be able to call him? Because it was Mohane's number that was written down. I was never signed in by Gininda at any police station, not even once.
They are clocking him. They are clocking. Ntanzi is clocking even the judge himself.
Yes. Secondly, there is no letter indicating that I was visited by a lawyer at a police station. Even now, Gininda as a brigadier, there's not a letter that he signed that says he came to see me at Pretoria North Police Station. The prosecutor read a letter from Jamestown Primrose. He said there is nowhere where it is written that Gininda came to see me. Now he's telling me that he came to see me with a lawyer. Remember at the Primrose station, police station, where Ntanzi said that he had this deal conversation with Gininda and Mohula and Mapena.
Yes.
And they then Baloi says that never happened. He even put it in Ntanzi that never happened, right? And I guess this is where it looks like they have an alleged tendency of not liking to fill in stuff when they go to the police station. It came in handy for them. But now,
as Ntanzi would put it.
but now, Baloi wants to impose this so-called visitation that Gininda made on the 23rd of June 2020 to Ntanzi to check his lawyer Mjiako, his alleged lawyer Mjiako. He wants to impose that on Ntanzi to say that took place, and Ntanzi saying that did not take place. Now he can't produce anything to substantiate that took place, including Mjiako's testimony himself, to say yes I was there or no I was not there. Yeah. Well, then he said that there is nowhere where it's written that Gininda came to see me. Now he's telling me that he came to see me with a lawyer. Where did he sign as a brigadier? My lord, that is not true. Even the lawyer never came to me. He didn't come to see me with Mohula and Mabena. There is nowhere where he wrote stating that he came to see me with Mohula and Mabena. So the issue of the lawyer is not true. Ngima lapho Nkosi enkantolo. Ntanzi said that even you are saying, prosecutor, you are telling the court that Gininda is saying that he was called. Where do they get this number at the police station of Gininda? Because it is Mohani's number that was written down. Okay, let's say the lawyer came to the police station to visit me. They must now call the police informing them that they are going to pay me a visit. Here is Mr. Ramosipili. He comes to see me in jail. I've never heard of him say that he's calling Mlaudzi, Mohola or Mokwena. He was speaking this in reference to what Gininda testified by saying that he was called by some police officer who has no name to come to the police station because Mjiako is at the police station and he's consulting with Ntanzi. Just before Ntanzi is being made to go and allegedly confess. So he's saying that there's no such. Mr. Ramosipili, when he comes and consults with me, he doesn't go through the investigating officers to come and see me at jail. He doesn't call Mlaudzi, he doesn't call Mohola or Mokwena informing them that he's coming to see me. He said, I've never heard of that. I'm starting to hear it for the first time today. That is why I'm telling the court, these are blatant lies. This is not the truth. Baloi said, sir, we asked you a very simple question as you mentioned that Brigadier Gininda came to see you with Sergeant Mohola and Sergeant Mabena. We asked you as to when did that take place. He's been asking Ntanzi this question for the gazillionth time. I am so tired of this man. I want him to sit down. I am exhausted. Advocate Buloi's cross-examination. Then Ntanzi said, I don't remember the date and time. Even if as I've been standing before this court for 3 weeks, there's nowhere where you put it to me that the reason why you are prosecuting me is because of this and that. You haven't said that to me. Well, Baloi said, right. Do you remember at which police station this visitation occurred? And Ntanzi said, I did say before the court that I was detained in a different police station here, so I can't remember. which police station. The two police stations where I was stationed exactly amongst them. But it was not Valeria. It's between Pretoria North and Moot. Baloyi rehearsed the evidence of Gininda and said that he received a letter of appointment from Giaco. Well, he said Brigadier Gininda testified that since it was COVID time, that was the reason why he was contacted. And Tanzi said that's not true. I was never visited by a lawyer in the police station. And Baloyi said, according to Exhibit SSU, you were detained at Pretoria Moot Police Station on the 23rd of June 2020. It's now Pretoria Moot. And Tanzi said, who booked me out, taking me where? And Baloyi said, on the 23rd of June 2020, you were detained at Pretoria Moot Police Station. This we see in the evidence. Baloyi read the record of the 28th of November 2023, where Gininda said that he found Giaco with accused 2, and he informed or confirmed that he was his attorney. And Ntanzi said, my lord, that's not true. Here are the lawyers sitting here. They came to the police station and jail cells. There's somewhere where we write, we write and confirm that he did come to see me. I even told the court and gave an example that I stay in Koshimampuru. When Mr. Ramosepele comes to see me in jail, there is where they make him sign and state that he's a lawyer. And he will come and see me. Mr. Ramosepele is given a slip that he signs at the gate. And then he said, I also sign that slip and take it to the section. And then they sign it to demonstrate that I was with a lawyer. So Ntanzi is asking for that with concern to Giaco. Uguti, where is that type of evidence that indicates that he did consult with him inside the jail cells? Where is that proof? Well, regarding Gininda saying that he was called to the police station to come and see Ntanzi, a self-imposed lawyer, in my opinion, and he wanted to check if they would allow such a person. Ntanzi said that it's not true what Baloyi is saying. Gininda did not state who called him. This was, whether it was Mnisi Ngumalo Jonase, he does not state in the court. He said, I was called at the police station. This is Ntanzi now making an example. There's a police officer that Gininda is saying called him to come and see me. But he doesn't state the name of that police officer. We don't know whether that name of that police officer is Mnisi Ngumalo Jonase. He does not state in court. He said, I was called at the police station. He's stating hearsay. Into ngekho. Uti inzwabeti ngezulu. And that is a brigadier that we are referring to here in this court. Ach. Give Ntanzi his robe, okay? Give Ntanzi his LLB. Mnigeni LLB. Yeah, my God. Baloyi then said he further testified that he advised them to allow this person to consult with you, and that he will be making his way just to confirm the status of this individual. Ntanzi said, my lord, that's not true. You even hear the prosecutor putting it and saying he allowed the person who told him that I was at the police station. Who told him, Giaco, that Ntanzi was at the police station to begin with, especially around June after he got arrested? Who told him? Who invited him to be present in Ntanzi's confession with Gronier? Who did that? Who done did that? So he said it was at this point Baloyi now asked to take a long adjournment. Okay. It was at this point. But what really troubled me, I don't know whether he was joking or he was serious. Guys, did you hear that portion just before they went for the adjournment? The microphone was still on, and he said Ngiphetwe ingculaza, and he said that he was not all right, And I heard him speaking with someone. I think it was a female voice that I heard. And he said, we'll speak more in the car. I don't know whether he was serious or it's a joke or what. But it really, really did not sit well with me. I'm concerned. I'm troubled by it. I don't know. It just kept haunting me the entire day on Friday because I didn't know what to do with it, But then we'll see. After the long adjournment, Baloyi now moved to a different topic. But first, he wanted to seek permission from the court to cross-examine Tanzi on the basis of his bail affidavit. Baloyi said that this is admissible in terms of Section 6011C. The section states that the record of the bail proceedings, excluding the information relating to the record of previous conviction, shall form part of the record of the trial of the accused, following upon such bail proceedings, provided that either the accused elects to testify during the course of the bail proceedings. The court must inform him or her of the fact that anything he or she says may be used against him or her at his or her trial, and such evidence becomes admissible if in any subsequent proceedings. It's a norm that anything you say in a bail hearing can be used in the main trial against you or whatever. It's something that's not a train smash, or it's a law, it's a prescribed law. You can do that. I've seen it being done before on many occasions, where what you say in your bail application is being used against you at a later stage in court. It does happen. So I wasn't particularly shocked, or rather against what he was requesting. Then Baloyi said, we therefore submit that on the basis of Section 11BC, that the state should be able to cross-examine the accused Mr. Ntanzi on the basis of his affidavit. He said there have been several cases on this point, and first one that we just quickly refer to is in the 2011 Volume 2 SACR, and is a judgment by Judge Museneke of Gauteng Local Division, Johannesburg. State versus Mia and others. Baloyi continued reading, and he said in that case, the judge basically held that if a witness in terms of Section 204 testified its subsequent proceedings, that the section still applies. In that instance, it does not distinguish whether one is a witness or an accused. The court held that whether as follows: the question was not whether the witness in question was a witness or an accused, because the protection was drawn from Section 11BC, and that Section 203 or 204 was not the issue. Said the correct interpretation of Section 11BC was that by reason of protection the witness enjoyed in another case, he was equally protected in the present case, even though he was a witness, and that court held that he had not been warned in the bail proceedings in the sentence case, and therefore that the section applied. Baloyi whipped out another book, and said that there was another case in the Cape Division of State versus Ames, and another in the 1998 Volume 1 SACR, page 343. And he says that in that case there were two accused. Accused one was not represented during the bail proceedings in the magistrate court, whereas accused two enjoyed legal representation, and accused one then testified in the bail proceedings, and accused two sought to cross-examine accused number one on the bail evidence. The Judge Desai, was the judge at the time, and he said that the court held that in light of the fact that accused number one was not legally represented during bail proceedings, that it would render the trial unfair. But then at the same time, the court held that it would infringe accused number two's rights to a fair trial. The court allowed cross-examination on the bail evidence and held that bail evidence might be admitted as evidence for the specific purpose of assisting accused number two in his defense by cross-examination, or otherwise subject to the rider that it would not be admissible as evidence against accused number one on the merits as being a statement of truth of the contents. And then the court then held that bail evidence should be admitted accordingly. He said, we therefore submit, my lord, that in terms of Section 6011BC, that the affidavit or the bail affidavit made by Mr. Ntanzi was legally represented. Such cross-examination be permitted. I don't know if there will be any other objections from my colleagues. And Mnisi said, well, it's a long-standing procedure, my lord. And the judge said, what is a long-standing procedure? Nisi said, I'm getting there. Bail proceedings would, in certain deserving circumstances, be evidence that could be dealt with in a subsequent, provided that all those necessary stop valves, those precautionary measures when the bail application itself was being entertained or had been held, put in place, my lord. Remember that it took quite some time before Ntanzi was able to get his bail hearing. I think it was over a year. The trial was ongoing while he was applying for that bail. And the judgment came before this judge came in. I remember. Before this current judge Ratha presided over the matter, Ntanzi was busy with the bail application. And it took months, I tell you, months. So already you could see that there was also resistance of granting him bail. Right. So it was weird times to be looking at what was going on at the time. That, oh my God, he's a first-time offender. Okay, he has a job. He has a place of employment. He's gainfully employed. Why are you denying him bail? It didn't make sense at the time, but now it does. Now it does, seeing that this whole case is literally on accused number 2's so-called confession that he made. He denies making it, but the state is saying he made it. Because everything is just weird. So on the other face of it, Mnisi said there could be no objection based on sound reason that bail proceedings can never be used in the subsequent, provided that those prerequisites are met. Those prerequisites refer to the proper advice of the accused as to what it is that they can say and what it is they cannot say, and what it is that can be used against him, etc., etc. It has been mentioned by the state that he has a legal representative. But having a legal representative only is not enough to guarantee that those measures were actually done. The little hiccup, though, in this instance is that the state cannot simply stand up and say we want to cross-examine him on the affidavit. That the state has got to introduce the entire record of the bail proceedings, which is true. If I recall correctly, the broadcast or the live broadcast that happened when it pertains to Ntanzi's bail application was the judgment. When Judge Ledwaba read the judgment as to why he was denying Ntanzi bail, but the proceedings themselves, I don't remember them being broadcasted as to how the lawyer who represented him at the time, I think it was Ramasipili if I'm not mistaken, and how he wrote the affidavit. We never got to hear even the details of Ntanzi's affidavit. So we'll be hearing them for the first time here, because I don't remember the proceedings being broadcasted in that manner. I only recall the judgment being broadcasted. An accused must, and I'm not saying that the state must prove the record, but what I'm saying is that the state has simply got to introduce the entire record of the bail proceedings, and the court must satisfy himself that indeed these were the proceedings of the bail application. Then from there, the state can then embark on its cross-examination. He said, I haven't heard of a situation where the defense objects to an accused being cross-examined on the basis of what he said in the bail application, provided that those measures that I've mentioned were put in place and are guaranteed, my lord. He said, may I further add that as the state intends to embark on the process now, we are a little bit constrained to follow the proceedings, because I'm not sure whether I've got that record from the voluminous papers that I have. I haven't come across it. I had a little discussion with Mr. Ramasipili when Counsel Baloyi was addressing the court, just to find out where this bail application was in the magistrate court, or where he informed me that it was actually done here meaning the Pretoria High Court. at a time when this case was already running before the Honorable Judge Maumela, and we are told that it was apparently done by Honorable Judge President Ledwaba, but I'm not privy to those proceedings. He said, I think I would basically request the state, if they have, at least we will be favored with those proceedings, but in essence there seems to be no objection that is coming from my part. Well, Ramasipili said, my lord, a bail statement is a statement made under oath, and a witness may be challenged with a statement made under oath. And I'm saying this because I'm opening the door, and I'm going to not object to the state leading or cross-examining the witness on the bail statement. It is a legitimate order to cross-examine. However, there are certain procedures that the person cross-examining on that statement must follow, is to confirm the identity which will be confirmed, to confirm that indeed bail proceedings did take place, to confirm further, my lord, that the statement was made freely and voluntarily, and the issue of legal representation has already been seen. Covered to say that he represented in those proceedings, my lord. So from our side, on behalf of Mr. Ntanzi, there are no legitimate objections to that process. He said, my lord, as the court pleases, and further, my lord, I do confirm that amongst my records, I have seen the proceedings of the bail application, and also the bail statement was furnished to me, but I don't have it here in court, but I've seen both. So Ngumalo said there's nothing that bars the state from using the bail record, but I'm not sure what is the record. I haven't read the record. I did have sight of the bail application record, and I'm not sure if the accused, Mr. Ntanzi, was forewarned to the effect that whatever he answered will be used against him. Now, this is also quite interesting, because since we don't have prior recordings of the proceedings of Ntanzi's bail hearing, it would be interesting to know if he was warned in this line to say that anything that you say, even in this bail hearing and bail application, it will be used against you in the court or in your main trial. I wonder if they warned him of that, because everything was just happening in a weird manner. So he said, so I'll find out prejudicial to me if the state continues to cross-examine Mr. Ntanzi on the contents of the bail record, because I don't have sight of what is contained in the records. He said, I want to have sight of it because I don't know what direction that the state is going to take. I need to see and go through the record. Mshololo said that she concurs with the defense for accused number 2. And then the judge said, Mr. Baloyi, what's your take? Mr. Ngumalo raises a pertinent question about the fact that he says he hasn't read the statement and he's not aware of it, and it's part of the record, he says. Well, Baloyi said we'll finish him with a copy, and then on Monday hear what his stance is. But then the judge said, I also want to read it. I'm not aware of the SCA, my apologies, Supreme Court of Appeal case on that point. Are you aware of it? And also, I don't know why he wants to reference a Supreme Court of Appeal case, because the defense did not object to anything. I don't understand that part. It's like he's preparing to argue, and I don't get why, because the defense didn't necessarily disagree or object with this request. Baloyi said not in the SCA, my lord. And the judge said, me, I want to be informed first. And then Ngumalo said, I also want to be informed. But then the judge said, okay, I see. Okay, fine. Look, generally, that is the position. If the position of S versus Nevason, I think it's an Afrikaans case, but it doesn't matter. But I just want to refresh myself on the basis tenet, so that, but critically also, I want to read the statement and understand it. I don't know. I don't even know what were the reasons for the refusal of bail, if it was refused. Well, here he is acting like, he cares. Acting like he will have the audacity to find anything wrong with Judge President Ledwaba's judgment. I don't know. I'm not expecting that. I'm not expecting him to be critical or to say that Ntanzi should have gotten bail. I'm expecting him to support that judgment and whatever it said. At the time, I remember it feeling like he's portraying Ntanzi to be this dangerous person who's a flight risk, who has the potential to run away. At the time, I get it, we didn't know that Ntanzi actually had a full-time job. It wasn't clear as to what his story was and who is Ntanzi and why is he in this case. We didn't have the details. But now that we have the details, and the details that they most likely had, because remember, they investigated. So it's mind-boggling as to how Ntanzi was denied bail. And then a couple of years later, here's a man accused of serious things, taking people out, 30-something bullets, allegedly. Okay. Even he's walking to court in a bulletproof vest, okay, to attend his matters and whatnot. And he granted that man bail. Okay. He granted him bail. The same judge. That baffles me. I still don't understand how Katie Molefe got bail and Ntanzi couldn't get bail. I'm still bewildered. I'm still stuck on it. It makes no sense to me. It really doesn't. Well, and he said, I don't even know what were the reasons for the refusal of bail. He said, whether Mr. Ntanzi or his counsel withdrew the application after some time, I don't know. They never withdrew the application. Ntanzi really wanted bail. Ntanzi wanted bail with all of his heart. Okay. He wanted bail. They just didn't want him to let him go, be in another space and seek legal counsel or seek counsel from other voices that were probably going to help him out of the situation. They didn't want that, allegedly. So he said, I want to appraise myself of all the facts. And Baloyi said there's a written judgment by the DJP, and the judge said I could have that, plus I have the written evidence. Baloyi said we don't have the transcribed record. We only have, so I'm going to speculate and assume that the only record that's available is the recording. This is Pretoria High Court. As to why that bail hearing doesn't have a transcribed record, it's strange. It was a high profile case. You can't tell me that you couldn't make a transcribed record. Why? Why didn't you transcribe the record? He said, we'll make the information that we have available to my colleagues, And I was hoping he would say voice recorded record or something that the defense can use, because they need the entire proceedings. The judgment Yalidwaba is not enough, because they still have to compare it with what was in Ntanzi's affidavit, as well as what the testimonies and who came and testified on behalf of Ntanzi to try and get bail, and what the investigating officer said, the reasons why he should not get bail. We need all of that, but it seems that it's going to be coming in drips and drabs. I hope the defense is given the entire record. That's what I'm hoping for tomorrow or today, early in the morning when they resume. Well, Ramasipili said, my opinion is that the court cannot have sight of the evidence until it is handed up in court as an exhibit. The judge said, so you want them to hand it up and then I must have sight of it, not knowing what was handed up. This is strange. Usually the judge would be like, I don't know what is in there. And you can tell that he's not given the evidence prior, right? So now when it comes to the bail hearing, he's very eager. He wants to know what happened with the bail application and what went wrong. He's very eager, and I don't understand the excitement. Maybe it will make sense later today why he's so excited to go through the bail proceedings of Ntanzi. because Friday didn't make sense to me. You can never just take anything with a cup of salt when it comes to that courtroom. You just have to take it with a pinch, not a cup. Ramasipili then said yes, and then the judge said no, it doesn't work like that. I have to read it. I know it's not like I don't know the law, governing that. It's I told it's state versus I told you it's state versus Nevason, and Ramasipili said I also know state versus water. The judge said fine, so I don't know which court is going to allow a document to be handed up without appetizing itself of that document. Are you with me? Here, since it's a bail application thingy, maybe that's why he's so confident that he can be able to go through it, because it's a part of the trial. It's like going through an old transcript. Is not evidence coming from outside. But generally with the judge, when exhibits are handed up, he mustn't go through them. He goes through them after they've been handed up. That's how the process is. But it seems like with Ntanzi's bail hearing, he would like a different approach. He would like to prepare himself like he is the state prosecutor who's going to be counter-arguing what the defense will be arguing, while the defense is not planning on arguing this one. They said they don't have a problem with it. Advocate Baloy can continue. But here's the judge making all sorts of preparations. I don't know, but something is cooking. Hey, something will be happening today. Ramasipili then said, but the evidence that has been presented here exhibits Mr. Baloyi, then handed up at the end. That is the procedure, I know. And then Baloyi said that he will make the record available as soon as they adjourn. The judge said he would like to have a copy of the judgment, minimum, at least. That's what he's requesting, at least. Well, he said some judges are wrong sometimes, okay? Sometimes they miss the point, sometimes they don't. But I can't go in there blindfolded, not knowing, like a bat. And then Mbalo said, I'm just worried about my lord. It is an inquisitorial system, though, because the court wants to have sight of the record before it is presented. The judge said, no, I don't want to decide on the record. I want to know what was said and done. That's all I must know. You want me to go on in blindfolded? Then Mbalo said, because it has to be introduced by the state, and then the court can have sight of what is contained there. The judge said, because in my view, it is unlawful, so I will rule that he cannot introduce it. I don't know what's in that thing and that you are saying. I mustn't know. And then Mbalo said, until the state introduces that information. The judge said, nah, he's told me that he is introducing the bail record. Is that not so? And Mbalo said, indeed, sir. If one looks at the record, it says that the bail proceedings shall form part of the recording or the record of the trial of the accused. Well, the judge said, where was that happened? And Baloyi said, except the information regarding the previous conviction and so on. The judge then asked what else, and Baloyi said, following upon such bail proceedings. So in fact, those proceedings automatically form part of, I think he wanted to say, this matter. And then the judge said, yeah, they are. But I must see that. And then court adjourned. So the judge is really insisting on going through Ntanzi's bail appearance, bail record. They don't have transcribed records, by the way, which is weird because it's a Pretoria High Court. They should be there, but they're not there. But the judge is insisting on going through it before Monday or before today when they resume. What do you think about that? Why is he so eager to want to know what happened in Ntanzi's bail application?
He's doing what he has been doing, which is to make sure that, I don't know, for him, it looks correct. Certain things for him, they look correct if they're done in a certain way. That's how he operates, in my opinion. Like, it's scary, man, how he does things. That's why he would like to go through the whole thing. Because to him, once there's something that is talking about that place or any time mentioning that place, then that is that. It is true. It is what it is. That's how they are thinking, even the judge.
I find it very strange. I'm like, yo, he's so eager to want to know what happened in the bail application. And it's almost like they found something juicy. They can't
They
wait.
did, obviously. That was a mess of a bail itself. Because, I mean, it was
Yeah, it was
shitty.
a messy bail. It was. I remember being so hurt on Dante's behalf. It was a mess. It was a mess. And it took approximately more than 7 months before he got to sit for the matter. And then Judge Lidor was saying that he couldn't get any other judge to preside over the matter. But where was Maumela? Because Maumela could also fit in to handle that matter.
Maybe,
Or get another judge. He said
maybe
none of the judges-
he couldn't brief the judge, so he needed to make sure that it was him.
It was so strange, guys. Like a whole judge president presiding over Ntanzi's bail matter. Sure, it was so strange. It was so strange. But yeah, we'll see tomorrow what happens.
Today,
Guys. I'm still stuck in the weekend. It feels like 2 minutes.
And guys, thank you. Again, press that like button. Make sure you press it like you mean it. And well, you see others are saying, where is Mr. Nomazo said cha ngilalanga bafethu befuna ukuqeda kunzima ukuma lapha phela mina ngisakaza lapha emsakazweni ngilele ngimile ngenyawo standing so ngoba nesitulo kasona sibhlungu nje singaso. So we are here and we are pushing, we are doing what we need to do. You also assist us. Through you, we can be able to reach our targets of likes and engagement and all that. Through you, we appreciate you in advance before you even press. We appreciate you. I'm sure we will I'll get the chance of listening again to that, what do you call it, bail. I'll get that chance. But probably it will be too late because the judge has obviously ruled however he ruled.
Yeah, definitely. I feel like they found something that they will use, and he's excited. He can't even, hide it. The excitement of what could be in that affidavit of Ntanzi.
They don't care, and then very soon they will be shocked when things come out. Because that's how they move. But guys, Yabonga, thank you very much. From my side, Emily.
Hi, from my side,
It's
you
a
guys,
bye.
it's a bye. I'm exhausted, okay?
Me too.
I have to rest, Nyana, and then at 10 o'clock attend to Dabaila.
Thank you, guys.
See you later.